Liz said, my name's Adam Willoughby. I'm a barrister. I practice in employment law and I'm from Broadway House Chambers, and we're based in Leeds and Bradford. I'm part of a team of about 15 barristers who specialise in employment law, and in my chambers there are also barristers who specialise in other areas, family crime and commercial and what have you. But one of my specialisms is employment law, and it's my pleasure to come and speak to you today. As Liz said, the way in which I really want to approach this, instead of lecturing you on employment law, because there's a quite a nice sized group, I thought it would be good to have your thoughts really, and see where, from a HR and a legal perspective, perhaps you think this area is going. And any queries you have, do put in the chat box, and I'll do my best to read and respond and present at the same time. Bear with me if I don't see your question straight away. Liz will poke me with her large stick, and I will answer them. So do put them in the chat box. If there's anything specific, and it's probably going to be in too much detail, then do feel free to email me. Liz is going to put my email address in the chat box now. I'll take a note, and do feel free to email me, and I'll respond as quickly as I can. So this talk really is going to be as much answering your questions as it is presentation. But to get us started, that's the content I intend to go through. We'll review the statutory provisions. We'll look at how our domestic courts have interpreted the holiday pay provisions, if I can call them that. You'll then have heard from in the media and in law reports and that sort of thing of cases of Williams and Locke, Bear Scotland, and there are quite a few other cases floating about which are really determining, if you like, the holiday pay litigation and the direction it's going in. So I've put on the slide there, poking the bear. I'm going to see how far we can stretch the case of Bear Scotland, the decision in Bear Scotland, and see from a claimant and a respondent perspective how that impacts our businesses, and then look to the future and see what, as employers, you can do to protect yourself against potentially quite significant liabilities for unpaid holiday pay claims, and we'll see how those can be brought. I should say at the very start, any answers I give, it's the usual legal disclaimer. It's not legal advice, but do just take them as guidance. It's more of a sort of an academic lecture or academic response rather than legal advice, so they don't constitute legal advice. So the starting point, and as I say, do feel free to chip in as we go. The starting point is Article 7 of the Working Time Directive. That's given to us from Europe, and what that says is that member states, so our country, shall take the measures necessary to ensure that every worker is entitled to be paid annual leave of at least 4 weeks. So we're given 4 weeks, and as most of you know, in addition to that, our own government, it was the Labour government, gave us an additional 1.6 weeks. There's a difference between those two sets of leave. So our working time regulations implement what Europe said we had to do. So we were given the 4 weeks, and then, so that's our Euro leave, that's our leave given to us from Europe. And in addition to that, we're given an extra 1.6 weeks, which is our domestic leave. So we've got Euro leave of 4 weeks, domestic leave of 1.6 weeks. All of what you've heard in the media about these cases stretching the boundaries of how much an individual should be paid for their holiday pay, it's concerning the 4 weeks leave. So it's how have we interpreted what Europe has told us to do, and therefore how have we given effect to that, and have we done it properly? And those were the questions being asked in those cases of Locke, Williams and Bear, and that's what we'll come on to. What Europe does is tell us that we have to have the 4 weeks, and that we have to take those 4 weeks in a year, and you can't carry them over except in certain circumstances. So we know we've got to have 4 weeks, and then we know it's got to be paid, but what they don't do, helpfully, or rather unhelpfully, is tell us how we calculate how much an individual should be paid for that 4 weeks leave when they're on holiday. Um, our own interpretation of that domestically has been to look at the Employment Rights Act to see how a week's pay is calculated, for example. What we've done is we've looked at sections 221 to 224 and section 234 of the Employment Rights Act and thought, well, that gives us a definition of a week's pay, so we'll adopt that. But that's rather unhelpful in many ways, because what that does is really scupper any clear understanding of how much an individual should be paid, and this is the reason for it. Sometimes individuals will be working, will have normal hours, normal working hours, and so from our perspective, when we're calculating how much an individual should be paid, we can see, well, they've got normal working hours, therefore we'll pay them what they would normally get when working their normal hours. However, sometimes an individual working normal hours will also be able to earn a bit extra. That may be because we've offered them some overtime which they have to take when offered. It may be because they've earned some commission. Now, in those circumstances, this is where we're scuppered, because we look at the Employment Rights Act, we look at the working time regulations, and there's nothing to help us in those situations, and that's what the courts have been grappling with, and that's the challenge for you as employers at the moment. Historically, there are a couple of cases in our domestic courts which looked at whether or not those sorts of additional amounts when an individual is working normal hours, which are defined in the statute as those hours which are set out in the contract and not these additional hours which are not guaranteed in the contract. The courts have said, well, any additional amounts, such as commission, should not be taken into account when paying holiday pay. And the cases which I'm referring to are a case of Evans versus Malley Organisation and a case of BAMSI. You'll see there, in those cases, BAMSI concerned overtime and Evans concerned commission. And our domestic court said, we're not interested in those additional amounts. All you have to pay in terms of holiday pay is what's set out in the contract, what those normal working hours normally receive by way of remuneration. Now I'm going to pause at that point because I want to do a poll, and for the benefit of Liz, it's 1.2. I'm going to put a poll on the screen. So what I want you to do is just have a look at this poll, and before we launch into the new legislation, just have a vote on when paying holiday pay, which you pay. Do you pay basic only, or what the employee would have received had they not been off? That's interesting. So most of you are paying basic only. So broadcast those results. So 8 of you basic only, 3 of you what they would have normally received. Well, those of you who were paying basic only, in the circumstances we've been discussing, that would fit quite nicely with the case law as it was in 2003 and 2004. So that fits in with Evans and it fits in with BAMSI. So just so we can plot this chronologically, up until 2011 it was, you were right, you only get your basic pay. However, we have a case in 2011 called Williams versus British Airways. Now that concerned some pilots who they got several different enhancements to their pay. So British Airways had calculated holiday pay only on the basis of basic pay, so as 8 of you would have done. Whereas the pilots wanted holiday pay calculated on additional elements comprising of they had a flying pay, which was an hourly enhancement for the time they were in the air, and a time away pay, of which 18% was taxable. That time away pay was essentially paying for their expenses. Now, under the Aviation Directive, which sets out how much pilots should be paid, what that says is they should be paid their annual leave, and nothing defined what annual leave, what their pay in that annual leave should have been. The pilot said, well, we want our enhancements when we're off. British Airways said, well, hang on, when you are on holiday, why should you be getting your flying pay because you're not in the air? Why should you be getting your time away pay? Because you're not away. Now this case went on and on and on, and eventually what we had was a decision which set out that pay intended exclusively to cover occasional or ancillary costs arising at the time of performance which the worker is required to carry out under the contract, are such as costs connected with the time the pilots have to spend away from base is not within the definition of holiday pay. So we have a situation there where the court at first instance has said normal remuneration does not include this time away pay and the flying pay. As the case moved on to the Supreme Court, we have a widening of what is normal pay. To that extent, you see on the screen there the quote. So what they are entitled to are all the components intrinsically linked to the performance of the task which he's required to carry out under his contract of employment, and in respect of which a monetary amount included in the calculation of his total remuneration is provided, and second, to all the elements relating to his personal and professional status as an airline pilot. So what we see there, you have to look at what the payment and whether or not it's whether or not they were being paid their sort of supplements, if you like, for staying away, their expenses, or whether it was pay. The pilots were obviously saying this was pay. We're not just being paid sort of supplements for staying in hotels to cover the expenses of that. We're being paid an amount which is, because it's taxable, and you remember earlier I said the 18% was taxable. Because it's taxable, it's part of our pay. So Williams really set the scene, and the Supreme Court's decision set the scene for us having an additional amount included in holiday pay, so not just for basic pay. We then have, after Williams, the case of Locke. And most of you will have heard of the case of Locke versus British Gas. Again, what we were looking at there is whether or not certain elements that an employee would get are intrinsically linked to the pay they're getting, whether it's directly linked to the performance of the tasks they're required to carry out under the contract. Now, in the case of Locke, commission in that case met the test. So Mr. Locke, most of his pay was made up of commission, and Mr. Locke averred in his case that he should be entitled to that. And in Locke, they relied upon the decision of Williams and said, well, in that case, the pilots were getting an enhanced amount because they were the pay was linked to their performance, and therefore, when they were on holiday, they should get that additional amount. And Locke really, because they said the commission was so closely linked, so directly linked to the performance of the task, he could get the commission. How many of you, just type in the chat box, think that Locke was decided correctly? How many of you think an employee who is usually earning commission, who's commission makes up the majority of their pay, and in that case, in Locke, it was a significant amount. That's really interesting. How many of you think it was decided correctly? You see, many employers I've met, it is, Eleni, I agree, it's difficult to say. Many employers that I meet think Locke is nonsense because they should just get their basic. And they think we should go back to the good old days of the case of Evans and Bamsey, which I was telling you about earlier, where holiday pay was um, restricted simply to basic pay. So we have this widening in Williams of the pilots. We have this widening in Locke of what can be included in holiday pay. So Locke dealt with commission, but there was still this uncertain question after Locke. What about overtime? Now, how many of you, I don't know if we've got a poll on this, so it may be that you can just type in the chat box. How many of you think that overtime, where you're not obliged as an employer to offer it, but when it is offered, you should, an employee has to take it. How many of you think that should be included in holiday pay? Okay, that's really interesting. And can any of you, it's not an exam, but can any of you say why you think commission should be included, or why, but you don't think that that sort of overtime, if it's, let's assume it's frequently done. Let's assume I'm working at a restaurant. I normally do 38 hours. If my employer offers me an extra 10 hours now and again, probably every fortnight, let's say, I'm obliged to take them. How many of you think that, uh, or what do you think is the difference between the commission and the overtime? Can any of you say that? That's interesting, Vicky. Yeah. I suppose, and Vicky, that I'm going to use that as a nice sort of segue into the next part of this talk, because yeah, that's really interesting. Uh, Amanda, I think that commission is earned whilst performing their normal hours of work. Um, they're really interesting points. So what Vicky's point was, Vicky said if overtime is voluntary, don't think you should get it. It's not normal pay. And this is the sort of difficulty we had in Bear Scotland. Whether overtime, which the employee has no right to, but must accept if offered. So that's the so-called non-guaranteed overtime. Should that be included in the calculation of holiday pay? Well, what Justice Langstaff did is say that if it's part of the normal pay and that which is normally received, then that should be included in holiday pay. Now, I suppose I called this pushing the boundaries of the case law, and what I was really referring to is the case of Bear. If as an employer you say, well, actually, Joe Bloggs only does overtime every other month, for example, and it's not not what he would normally get. I mean, he does have to come in if we offer the hours, if we're particularly busy, but it's not what they would normally get. There's going to be a lot of argument over this word normal, and as a lawyer, lawyers are the last people to tell you what's normal, because anyone, I suppose, it's difficult to say what is normal. Um, it normal is without definition. I suppose you have to look back, and in my view, you have to look back over how frequently they have done such an overtime. But Bear certainly does, despite many of you saying it shouldn't. Um, Bear does, in many ways, um, pose a difficulty if you are an employer who is at the moment only paying basic. If you're only paying basic, pay when when an individual's on holiday, you may come unstuck when it comes to their overtime. Now you have to look at what is normal. You have to go back. How far back has Joe Bloggs performed this overtime? How regularly has Joe Bloggs performed this overtime? If it's with sufficient frequency, then you'll probably want to include that in holiday pay, in my view. What BEAR doesn't do is determine whether or not truly voluntary overtime should be included in uh, the calculation of holiday pay. How many of you, just in the chat box now, think that truly voluntary overtime, and I'll give that a definition, so an employer doesn't have to offer it, and an employee doesn't have to accept it. So how many of you think that should be included in the calculation of holiday pay? Okay, I think it's a unanimous no, I think. Okay. So my view is that the way in which this litigation is going, it's going to be included. That's my view. And Nigel, I agree with you. I think Nigel says yes. I think the direction in which it's going is that we're going to be including purely voluntary overtime in the general calculation of holiday pay. The reason I say that is um, Mr. Langstaff, the judge in the case of BEAR Scotland, Judge Langstaff, relied upon the term required when determining whether or not non-voluntary overtime should be included as holiday pay. Well, if we're looking at the word required, arguably if an individual is carrying out purely voluntary overtime, when they're on their shift, if they are a bus driver and they're on their shift, and they're 3 hours into a 4-hour shift, and they say, excuse me, I've had enough, I want to go home, you as the employer would say, well, hang on, you're required to do this job. On that basis, I think, on a proper reading of BEAR Scotland, you could argue that that term required extends voluntary overtime, extends holiday pay calculations to purely voluntary overtime. That, I think, is something employers at the moment really, really need to be aware of. And the reason is, as I say, Judge Langstaff, when he was talking about whether or not non-guaranteed overtime should be included, he used the term required. If an individual is required to come and do this non-guaranteed overtime, arguably when someone puts their name on the roster to do purely voluntary overtime, then they are required. I think there's going to be a lot of litigation extending over this term required. I've got, excuse me, I've got at the moment 3 or 4 cases on which are centered around this term required, and what we really need is the EAT to tell us whether or not voluntary overtime is going to be included. Now, excuse me, what I want to move on to next is sort of practically what, as employers, we can do to mitigate. Sorry, I'm just catching up on the slides. No, that's fine. To mitigate the damage caused by BEAR. So if we have a situation in which we've got non-voluntary overtime and we've got voluntary overtime, you as the employers are probably going to be facing pretty large bills in the future if you have employees bringing claims against you for non-paid holiday pay or underpaid holiday pay. Now, what they can do is, as I say, bring a claim in the employment tribunal, but you do have the deductions from wages regulations, which to a large extent are going to mitigate the damage caused by these claims for employers. Now that those particular regulations do put a 2-year limit on any back claims, and what they would have to prove, what an employee would have to prove, is that there is this unbroken chain every 3 months, and that's what Langstaff did in Bear Scotland. He said there would have to be a series of deductions with no more than 3 months apart. But now we have the Vince Cable's new regulations, which, even if they do have the 3 months continuity between the time they were off and therefore the time they've experienced the deductions, they've got this 2-year limit anyway. Now, in my view, those regulations are liable to be challenged on the basis of how they were brought about. That's probably a talk for another day, but they were certainly introduced on, I would say, an uncertain legal basis, and I won't go any further than that. But if you do face, as employers, if you do face these claims for holiday pay, how do you think, and again, feel free to type in the chat box, how do you think you can best mitigate against that? So what sort of measures, you may have put some measures in place, but what sort of measures do you think you can put in place to mitigate? Nigel, just while I'm waiting for people to type that, what do you mean? Do you have an expectation of time? There's several. I'm just going to wait for several of you are typing. Okay. Okay. Nigel, I think you're probably going to be looking at towards summer next year before we get any sort of decision on whether or not truly voluntary overtime is going to be included. Leslie, I think that's always a good idea to look at the previous 12 weeks hours. I think that's always quite wise. And of course that is what's required anyway if an individual has non-normal working hours. I think that's always quite a good thing to do. So look at the average, because that will give you the answer to what is normal. I suppose just moving on to what you can do, look out for what the cases are going to be deciding. Nigel, you'll see there I've put on the screen, Lock is going to be decided. You've got the issues there on the screen. That's going to be the issues that they're going to be deciding. That's going to be decided on the 8th to the 9th of, or heard on the 8th to the 9th of December. I think it's going to be some time before we really know whether or not truly voluntary overtime will be included. We already know that non-guaranteed overtime is included. As I say, potentially employers face quite a significant bill. I think there are ways to limit. I think it's very unusual to have a situation in which an employee will perfectly have this gap of 3 months between their holiday. And so I think it's going to be quite difficult for them to establish that there has been this series of deductions. But you never know. It doesn't always. It's not always that difficult for someone to prove that they've taken regularly sort of a day off a month for holiday, for example. Do any of you have any specific or any questions on what we've covered so far? And I'll address them at this juncture. Nigel, I think that's sometimes wise to wait until the law's changed and then and then go back and correct it. I know from experience that quite a few employers are setting aside significant amounts of money just in case. And it's rather becoming a bit like the PPI saga with some of these holiday pay, some mass litigation. The other thing some employers are doing, and this isn't necessarily my advice or view on best practice, but are getting auditors in to look at potential liabilities if truly voluntary overtime is included. And some employers are taking a very robust view in saying, well, look, we're not going to change from the BAMSI days of just paying basic. We're going to keep just paying basic, even if someone's on commission, even if they've regularly been doing non-guaranteed overtime, even if they've been doing voluntary overtime. We're not going to change it. And the reason we're not going to change it is because the law may change back to an employer's favour. I don't think it will. My own view, as a barrister practicing in tribunals and in the EAT at the moment, I don't think that's the direction we're going in. The European jurisprudence is all going in one direction, and that's that we should really look after employees and their health and safety is paramount, and therefore they need time off. So I think the direction is that employees are going to be getting more money in their pay packets when they've been off. Kerry asked, do you have any thoughts on a shift allowance payment? Should this be covered under holiday pay? Kerry, that's a really good question, and that's something I was also going to come on to. So, we're looking at what are they normally paid? What are they usually paid? Well, I have a case at the moment involving, I won't name the companies, but road workers who go out on the motorway at night and they repair the motorway, repair the barriers that we see. Now, what they have is a nighttime working allowance. They have shift enhancement allowances. They get a sort of a shift premium, and they get a dirty hands bonus, believe it or not. It's £1 an hour for getting oil and grease and dirt on their hands. I'm arguing on behalf of employers they should not be allowed those elements of their pay because what we're concerned with is what they get for what they do, and at the moment there are no cases which establish employees, to my knowledge anyway, employees should get beyond commission and pay sort of the usual pay, the usual hourly pay, whether it's a voluntary overtime or for their basic hours. I think I'm on shaky ground on that argument because those elements of pay are intrinsically linked to the work they do. If you think about it, if they weren't doing the work, if they weren't doing those shifts, they wouldn't get those elements of pay. When they do the shifts, they get those elements of pay. So those elements are intrinsically linked to their basic pay and to any pay they get when they're doing overtime. So my view is that shift allowance payments are included, and I think we're going to have cases which show that, which establish that as a principle. My view is that employers should probably set aside, or certainly consider setting aside some money, not necessarily paying it to the employees at the moment, but set aside some money to protect themselves from potentially significant claims. If you have 10 workers who get a shift premium in a relatively small factory, they all make a claim because they've not received their holiday, not received sufficient holiday pay, then you're going to face potentially quite a significant liability. Leslie, I'm just going to read your question. Our employees get a lot of allowances linked to hours worked and have been including these. Well, I suppose, Leslie, you've acted on the cases as they develop, and you've seen, I suppose, the direction in which this is going, and you're one of the companies, I suppose, that have sort of decided to start paying these in order to avoid sort of having a mass load of claims. And often between us in this webinar, quite often employees, if they already look at their pay packet and they think, well, I'm getting a fair deal at the moment, they're not probably going to look at historically what they've lost out on. That's something to bear in mind. As I say, it depends. I'm not a psychologist. I'm not talking about the psychology of employees, but sometimes if they have seen that they've been getting these allowances linked to their hours worked in their holiday pay packet, then um, they may not be as aggrieved as someone who's just getting the basic, who watch the news at night and see, well, hang on, I did a bit of overtime. Let's see if I can claim it, even if it was purely voluntary overtime. Okay. I just want to do a quick poll. It's a poll I was going to do at the beginning, but I thought, having listened to all that, I would do it now. How many of you, or how are you feeling about the holiday pay saga? Are any of you worried about uh, the holiday pay issues which sort of you see in the news at the moment? Okay, so the majority of you are a little bit. Okay. I think that, I mean, that really is for my benefit. Is interesting to see. I think many employers have probably overreacted and have made knee-jerk decisions. I think my view is it's best to just see how this is going to sort of be played out. I think, as I've said to you, the direction in which it's going is that as employers you'll be paying more rather than less. um, I think we need to have a look at the case law which is developing. I don't think knee-jerk reactions should be made, but I do think it's wise to sort of take precautions at this stage. And particularly if you're a small company who probably cash flow isn't great, just set aside some money just in case you do face these claims. Uh, just be aware if the nature of these claims at the moment, they're all being lumped together in the tribunal. So many claimants, if their claims are similar, so if, for example, you have several employees claiming a certain shift allowance, then often their claims are grouped together, and you can, as employers, be dragged into group litigation claims, which are they're slow. They can be cost effective because you can sort of team up with other employers who are sort of in the same boat as you and share their costs. Um, but often you don't have any choice but to be involved in group litigation claims. So just be aware of that. Just moving on. Again, I'm going to open it up to questions. We've got a couple of minutes left. Martin McFarlane asks, how would you advise responding to a written request from an ex-employee claiming additional holiday pay? Well, that's, I suppose, quite specific. I don't want to, again, I don't want to give you legal advice, but um, if it's sort of a letter before action saying that, well, I've not been paid my holiday pay, the first thing I would be thinking is, well, are you within the time limit for bringing a claim? So are they within 3 months that of that deduction? It depends on how they're intending to bring a claim. If they bring a claim in the county court, then they probably are within the time limit. So that's something to consider with your solicitor, with your HR or legal advisors. So the first thing I would consider is, are they within time for bringing a claim? If they are, then obviously you need to respond to them by saying, but probably by arguing the points of, well, we paid you what was your normal pay, and therefore legally we're doing things right. It's quite a specific point. I'm happy for you to email me about it, but I would sit down with your legal advisors and work out whether they're sort of within the time or not. How far back are employees likely to be able to claim for? Let's do a poll. um, Julie, let's do a quick poll. What do you think? What do your colleagues in the room think? Okay, it's quite an even spread. Probably the majority of you saying, just the majority of you saying 3 months. Well, we have the series of deductions, so you need an unbroken series of deductions. So you need to have the underpayments every 3 months, in my view, at the moment. Um, at the moment, they can only go back 2 years, and that's one that's not on there, because I wanted to see how many of you think it's 3 months, 6 months, or back to when the regulations started. My view, again, is that this particular area, these particular sorts of claims, uh, for, from a claimant's perspective, are largely being successful. It's going in the claimant's favour is what I'm trying to say. So we could have a situation in which it's argued we go back to 98. I think that's a possibility, probably not a probability. My view is that the regulation, 2014 regulations, if not challenged, will put a cap on it for 2 years. So that's my view. Um, so again, it's uncertain. My view is at the moment 2 years, could go back to 1998. So that draws it to an end. I'm going to hand. Yeah, Liz has just shown me that there are some additional questions. Drop me an email with those on, and I'll respond. I'm going to hand back over to Liz now. It's been a pleasure talking to you, and I hope that's been useful. Thank you.
Thank you, Adam. Fantastic. Some really good advice and well, just sort of understanding the where you see it going and where sort of the movement of the law will be. I'm sure you'll all agree. Some really good insight there. So thank you, everybody. Our contact details there if you should need them. We'd love you to give us some feedback after today's session. I'm going to give you the pay complement website if you wouldn't mind just leaving us what your thoughts were from today. Brilliant. And next week we have workplace learning, how, what, and why, and what you can do as employers. And the week after we've got the manager's demons. So hope to see some of you again on either one of those. And Adam will be back. I can't say this. It's in the new year, isn't it? in the new year with some colleagues. We're going to do a bit of a Q&A session there. So I'll keep you posted on what that's going to be. That looks set to be quite something else. So keep you posted. Thank you everybody and ever so much for your support with the webinars today. And as always, have a good afternoon. Thank you.